We are here live today, and today is National Healthcare Decisions Day. We have with us Jamie Tare. Jamie Tare is with Smith Tare Legal.
That's right.
And Jamie's primary focus, her practice's primary focus is on wills and estates. She's located in Gwinnett County, and she brings with her an experience from the bench as well. Jamie is the Snellville Municipal Chief Judge, and she is also a magistrate court judge in Gwinnett County. Jamie, thank you for joining us today.
Thank you for having me.
How are you?
I am well. Thanks for asking. Things are going well. I know people are not happy about the shelter in place, but they really need to take this time and just slow down. Use what God's given us.
I agree. I think that is, I think there's a reason for this unfortunate tragedy. And I think that the earth is recovering.
Mm-hmm.
You know, it was supposed to be this way, and it's unfortunate, but I agree this is a time for us to reflect, restore, and rejuvenate.
Absolutely.
Yeah. So today we're going to talk about healthcare directives, and the purpose are, I guess, National Healthcare Decisions Day. It exists to inspire, to educate, to empower the public and providers about the importance of advanced care planning. I think that it is very appropriate for us to have this conversation in light of COVID and so many people being sick, becoming ill, and having to make decisions about their health care. Mm-hmm. So I thought it was very appropriate to have Jamie come on the show and talk about items people should be discussing and putting in place normally, like even without COVID, this should be happening. But in light of COVID, you definitely need to take care of some of these items. So Jamie, can you just in general explain what a healthcare directive is?
Okay. In the most basic terms, a healthcare directive is a document that says who you're appointing to make decisions for you in the event you're unable to. So say, for instance, you're in the hospital and you've been in a tragic car accident and they need to make a decision regarding your health care. Then whom can they talk to make those decisions for you when you cannot? It also generally gives someone the access to your medical records if you grant them the access through the advanced directive.
When is a good time to start thinking about healthcare directives?
Well, before something happens.
Right.
So, like you just said, since we have this time, we're sort of slowing down. You're sitting in your house outside of distance learning. You don't have much else going on. This would be a great opportunity to sit down and think about your advanced directive, in addition to a couple of other things. But at a minimum, you should be thinking about your advanced directive. And what better day than today?
Now, do it now. So when let's just kind of go through a scenario, when someone doesn't have a healthcare directive in place, they get sick, they go into the hospital, what happens and who makes the decisions?
Well, that's the thing. I always like to remind people about the Terri Schiavo. Depending on how old you are, you may remember when that happened. And she was in the hospital, she was in a coma, and there was this big debate between her husband and her family about what should happen. Should she continue on that life support or should it be discontinued? Now, in the real world, if you've ever been in this situation, typically when something happens, the doctor will come out to the family if they're sitting there and say, who do we talk to? But what if you have a situation when they don't know who to talk to or the family is at odds about what's going to happen? That's when you have a situation, and you could end up in a Terri Schiavo situation where now you're in months and months of litigation, attorney's fees, those kind of things, because the hospital wants to do something, the family wants to do something else, and then even within the family, there's contention about who's going to make that decision. So the advanced directive for healthcare says who's going to make that decision. It also gives you a lot of opportunity to decide who you want to make that decision. I think in a marriage situation, it's pretty clear, hopefully, who you want to make that decision is probably going to be your spouse. What if you think your spouse might be too emotional at that time, depending on what that decision has to be? Then you might want to appoint an adult child or even a close friend to make decisions. Or what if your spouse is also involved in the accident? Then who's going to make that decision? So those are the things that you need to be thinking about and why it's important to have an advance directive for healthcare. What if you don't have a spouse? What if you have children and you have 3 adult children? Who's going to make that decision? What if the children can't decide amongst themselves? Because the hospital will go through to the children. But what if 2 children want to do one thing, another child wants to do something else? So you need to start thinking about those different circumstances and instances and helping your family to ease some of that burden by making those decisions for them now.
And I think that's a great point, because you don't want your family at odds or to become at odds because of you.
And well, not just that, and they're already distraught. We're talking about a circumstance where they're already probably very distraught, and now they are coupled with this decision, and they're arguing about who's going to make the decision. And I'm not saying, because an advance directive for healthcare, I don't want to scare people and think this is, oh, I need this because something tragic is going to happen, because a lot of times people don't want to do it in that case. It's not just in a tragic accident. It's just you are unable to make a decision for yourself. And COVID-19 is a perfect example of that. Unfortunately, there has been a lot of death connected to COVID-19, but we also know there's been a lot of recovery too. So a lot of people are recovering, but during that period of time when they might not be able to make a decision, they're not going to die, but they might not be able to make a decision. They need someone there who can make those important decisions for them, like a ventilator.
Sure. Let's talk about specifically different documents that help or outline who should make decisions and what a hospital should do or what a person should do in the event that something happens. Specifically, first, let's just talk about a power of attorney. Explain to the viewers what exactly what the legal effect of a power of attorney is.
So first, I want to say that those are 2 different documents. So we have the advance directive for healthcare, and then you have a power of attorney. The advance directive for healthcare deals with healthcare. So that's the way you can think of it. When you hear the words advance directive for healthcare, you're talking about healthcare. Some people also call it a living will. That's what it used to be called a while back. We really don't do living wills anymore because it's all incorporated into the advance directive for healthcare. So the living will component is now in the advance directive for healthcare. In the past, we had 2 different documents. We had a durable power of attorney for healthcare and a living will. So now they've incorporated that into one document, and that's the advance directive for healthcare. Then you have the power of attorney. The power of attorney deals with finances. Now, a few years back, Georgia changed their power of attorney. It used to be a 2-page document. Now my power of attorney is about 8 to 10 pages, and it deals with finances, but it specifies different areas of your finances. So it's not just, it doesn't have to be general that they have decision making over your real estate, your bank accounts, if you have a trust set up. It outlines specifically what you want your agent to have the power over. It also gives you the opportunity to decide when that power of attorney will take effect. In the past, I used to do what's called a springing power of attorney. And in the springing power of attorney, it specifically outlined when the power of attorney would take effect. So it says that in the event I'm in the hospital or in the event I'm incapacitated, then this power of attorney takes effect. Well, I don't do that one anymore because they changed the power of attorney form. And so now the power of attorney document outlines when it can take effect. Some of them, you can say it takes effect immediately. So if it's a spouse or a child or somebody like that, you might want it to take effect immediately. But most likely you want it to take effect only in the event something happens and you're unable to make decisions.
And when you say, and I hate to interrupt you, but I just want to make the distinction for power of attorney to, if you wanted it to become effective immediately, immediately is upon execution of the actual document.
And that's where with my clients, I always tell them, be careful about making it. Can you hear me?
Yes, I'm just paying very good attention.
I always tell my clients, be careful about making it become effective immediately, because I give them the example that you could be sitting in your house and you saw a real estate agent put a sign in your yard because you've given somebody power of attorney over your real estate, and so now they're selling your house. So if you want to, when you're doing those, I think it is something that you need to do, but just be careful about when you make that become effective. So the power of attorney, to summarize again, the power of attorney deals with your finances, and the advanced medical directive for healthcare deals with your healthcare.
And I think you explained this earlier, but a living will is now a component of the advanced healthcare directive, or is it it is not a separate document? No. It is a component of the advanced healthcare directive.
That's correct. So in that portion of it, that's when we give a direction about being on life support. Mm-hmm. So it's saying that in the event I have a terminal condition and I'm on life support, or I'm in a coma, vegetative state, and I'm on life support, mm-hmm. and another physician has said there's no reasonable chance of recovery, then what do I want to see happen? And there are 3 options provided on that document. You can say, 1, keep me alive no matter what, do everything you have to do, hop the car, mortgage the house, whatever you have to do, make sure I stay alive. 2, you can say that discontinue everything and I don't want to be on life support. Or 3, you can say, well, I don't want to be on life support, but I do want them to continue certain things. Like you could say, I still want a ventilator. Or you could say, I still want nourishment. Or you could say, I still want hydration. Or you can outline specifically what you do want to continue to receive in those circumstances.
And that's the wonderful thing about taking control of what happens is you can be as general as you want, or you can be as specific as you want. And that, I think, goes to just the person taking control of their health care. And it just eliminates someone else having to make the decision on your behalf.
And not just eliminates them having to make the decision, but eliminates the guilt. Especially when we're talking about extreme circumstances where they are having to make the decision of whether or not to take you off life support. Making that decision for someone in advance will eliminate the guilt that they may have to live with for the rest of their lives.
Yes, that's really important. Before I go any further, I would like to make sure that everyone knows this is a live broadcast. Ask any questions that you have about wills and estates, because we have a professional Georgia licensed attorney, and I specify that because we are discussing Georgia laws. We can take your questions, we can give you maybe the Georgia approach, but if you are calling and have questions or sending a comment and you are in another state, you will have to speak with an attorney in your state. But please, comment, ask questions, share this broadcast. This is very important information, especially in light of COVID. Jamie, if people want to contact you, I'm going to put your number up here. Can they call your office directly at 678-253-8133?
Please, I'd be happy to talk to them and schedule an appointment.
And is that the best way to contact you, or would you also like welcome emails as well?
I welcome emails. However they need to contact me is fine. And you have my email address up there. It's at jterra@terralaw.com, or they can always email contact@terralaw.com. And they can go on my website at www.smithterra.com.
Okay, great. And I'll leave your email up there while I ask you the next question. What are some of the common mistakes people make when attempting to draft their own healthcare directives?
I actually haven't really seen anyone try to draft their own healthcare directive, luckily or thankfully. I've seen a lot of people draft their own wills.
Okay.
I haven't seen a lot of, I think generally with the healthcare directive, they just don't do it. That's really the problem with the advanced directive for healthcare, is not doing them. I would be really afraid of someone trying to draft their own advanced directive for healthcare. I don't even know what the doctor or the hospital would do with that.
Would do with it, right? So does a healthcare, and this is outside of my wheelhouse, let me just ask you this so that our viewers know. I do know that sometimes, the wills, I guess you have to have two witnesses. What is the legal, what makes the healthcare directive legal in terms of signatures?
And it's the same, you do need two witnesses.
Okay.
Many times, if anyone has ever been in the hospital, although I used to say this and apparently it's not true, I thought the hospital offered it to people, but that's not always the case. So it is something you want to talk to an attorney about, to make sure you have the proper document so that when you go to the hospital or when you go to the doctor's office that you have this. I always thought that whenever you were having surgery or something, it was automatically included as part of sort of the admissions, but it's not. So it's important that you do this in advance.
Okay. So if
anybody do it on their own, I would not encourage anybody to do it on their own. My advanced directive for healthcare is about 5 to 6 pages. And the funny thing is when I'm doing wills, we go through those and sometimes those, especially for most sizes, relatively small estates, those can go pretty quickly. But when we get to that advanced directive for healthcare, sometimes it takes longer than the will.
Interesting. So that was my next question. That's a good lead in to my next question. What is the process for someone to hire you for a healthcare directive? Like they come in, they're perfectly healthy. What's that conversation like? They just come in saying, I'm thinking about my future healthcare. Is that how or they come in for a will and then it's recommended? How does that work? What's that process like?
There are two situations that typically occur for my office. One, they're coming in for estate planning. And so we'll start by going over the basic needs for estate planning. So the basic needs for estate planning, just to outline those, are a will, an advanced directive for healthcare, and a power of attorney. Those are the basic things that I think everybody needs for basic estate planning. So they may come in and we're having that conversation. So then the advanced directive for healthcare is part of the estate planning process. But in some situations, I get somebody who calls because they are about to go into the hospital or a situation has arisen and they don't have access that they thought they should have. And they'll say, oh, we need to get this advanced directive for healthcare. So in some instances, someone will contact me just strictly for the purpose of obtaining an advanced directive for healthcare because something has come up and they realize they need one. But in most instances, it's included as part of the estate planning process.
Okay, great. You spoke earlier about the same signature requirements of a will being necessary for a healthcare directive.
No, I didn't say that.
I'm sorry.
I want to just correct that. That's not what I said. I said it was the same. You talked about 2 signatures, and yes, that is 2 signatures. That's not the same for a will. A will is a little different.
Okay.
So we do need those signatures for a will. I use for my office, and this isn't what's necessarily required, but I require it because I don't want the person to have to go and look for witnesses for a will. Then we do a notary too. So with our wills, they are notarized because we do what's called self-proving affidavit.
Okay.
So we have those 2 witnesses who are not listed in the will, and then they have to also, we also have that notarized. That with the advanced directive, and I didn't say this, whoever signs it, witnesses, they can't be the agent or the backup agent. So those also have to be 2 people who are not listed in that document. That's very important.
Great distinction.
You, Melanie, and then you witness it.
Right. Thank you for clearing that up. So what concessions are being made in terms of signing the documents in light of COVID?
Well, Governor Kemp passed, and I don't have it. I thought I brought it in here, but apparently I didn't. Governor Kemp passed something about notary signatures with witnessing. Since the advanced directive for healthcare doesn't have to be notarized, with the witness signatures, what you can do is similar to what we're doing right now, a live feed, so that you can see the person who's going to witness the document can actually witness you. So you hold it up and they can witness you signing it, and then they can sign it as well. So our office is still open and doing virtual signings, and that's the way we're handling them, is through video conferencing. Okay. And of course, if you're even though we have the shelter in place, if we send you the document and you have 2 witnesses where you can arrange where you're still 6 feet apart, then you can do it that way as well. Because I can be 6 feet from you and see you sign the document.
Right.
And this is also important to note. So once you get that signed original, you don't need the original for the doctor or the healthcare facility where you're going. A copy is sufficient. So once we give you a signed document, an original, then you can make copies of that and use the copies. The agent does not need the original. They can have copies.
And the person can keep their own originals. You don't keep those original documents.
That's right. And if the person chooses at some point to terminate that agent, then they would need to put that in writing and give it to the agent. I always also encourage people to give it to their doctor. I haven't heard of anybody going rogue with an advanced directive for healthcare and trying to use it. But in the event you thought that would happen, then you would give a copy of the termination of that agent to any facility that you went to.
Great. And we did not finish talking about a will. So if you could just talk about a will and again, go through the distinctions of a will and the advanced directive, the living will, and make those distinctions.
Okay, so a will is a document that outlines in the event of your death how you want your things to pass. So all these things that you've worked your life for, your house, your car, the furnishings in your home, the money in your bank, it says what you want to see happen with that stuff. And if you don't do that, then the state does make those decisions for you. A lot of people say, I don't want the state to get my stuff. Well, the state won't get your stuff, but the state will get to say what happens to your stuff. So in a will, you make those decisions without the state having to step in and make those decisions for you. Now, sometimes people will say things like, well, I don't care, I'm gone. But you do care because let's just say, for instance, you've been separated from your husband for 10 years. And then you pass and you don't have a will. Guess who gets it? We don't want that. You would care in that sense. You don't want that husband that you've been separated from and never bothered to divorce to get your stuff. And then in some cases, if you don't have a will and you have a husband and children, then it's divided. Not in some cases, the law says it's divided between your husband and children equally. Well, a lot of people don't want that either because they want their spouse to get their stuff. And then if they predecease them, then they want their children to get it.
Or the other way around, they want their children to get everything.
Or the other way around, especially if you have a blended family situation.
When
you just got married, then you might not want that spouse to get anything, and you want your children to get everything. Or if you don't have a spouse, and you've been supporting Johnny all his life, and your other 2 kids haven't gotten anything. Well, you wanted to go to your other 2 kids and not to Johnny. Mm-hmm. But if you don't have a will, then you don't have the ability to decide how it goes. And so that's what. A will, I don't understand why people don't do it because it gives you, just that I have worked very hard during my lifetime. And I want to make sure that the things that I have worked for go the way I want them to go and not the way that the government says that they have to go.
Right. Are there, and I agree with that. I think it's important for you to plan.
And this is something else. I'm sorry to cut you off.
That's okay.
Something else important to note with the power of attorney. So a power of attorney dies when you die. So with a power of attorney, that's when the will would then take effect. Or if you have a trust, then you don't even go through the paperwork process. And I always say trusts are a whole nother animal, but that's when the trust will take effect. So the power of attorney dies when you die. They can't use it once you die. So that's another reason why it's important that you plan for after you die. Because one thing we can count on, what did our parents always tell us? Death and taxes.
That's right. The guarantees of life.
Yeah.
That's right. So when someone comes in to you or to your firm, these are all the documents that you'll go through. And this is all part of estate planning. So when someone say, well, I don't really have anything, I don't have to go to see an estate attorney or wills and estate, I don't have much. What is your response to that, or to those people who say, I don't have any assets, I don't need one, I don't have to worry about it?
I always tell them they'd be shocked about what your family's going to fight over when you go, because your stuff is important. The furniture in your house, even if you don't own a home, the furniture in your house, you've taken time. Sometimes you've gotten into debt for that furniture, and you might want to be able to decide where it goes. The money in your bank account, if you don't have a will, they still have to be able to get that money out of the bank account. So they still have to go through the probate process to get that money out of the bank account. And you worked for that money. So even if there's $200 in there, you want to decide who's going to get that money. Now, there are probate hacks, so you can have a payable on death for the bank account so that they don't have to go through the probate process. But that's another reason why you need to see an attorney or to speak to somebody about these things, so you can figure out what's the best situation for you. How can we set this up so after you pass, it's easiest for your family and your stuff goes where you want it to go.
Jamie, we do have a question, and the question is, the will I have was outlined when I was married. I'm now divorced for several years, but there's nothing in that we would change. Do we still need to have a new one?
Well, yes, because that divorce is a change of circumstances. So the court sees that as you dying intestate. So yes, I would still recommend that you update that will. You can even just do a codicil, so you don't have to change it necessarily. It would just be an amendment to it to say that you got divorced, but this will is still in effect.
Now, correct me again, outside my wheelhouse, people. Be patient with these questions, but these are probably the kind of questions that you would have. So this is just a follow-up to that. You are saying that the divorce is a change in circumstances. Does that mean if she doesn't do a new will or a codicil to the existing will, that the will is null and void?
Well, the court says that, so say for instance, in her will, she got divorced and then she has some children, and I'm not sure of her, and she has children, adult children.
Yes.
And the adult children will then say, well, no, mom got divorced, so this will should be invalid, and the court can recognize that, because that's true. There was a change of circumstances, a significant change of circumstances. So that's why I recommend that even if she wants to keep it the same, that she do the codicil to say that she recognizes that this occurred, but it was her intention to keep this will the same.
That is such good information. Well, I'm sorry, what did you say?
Litigation as well. So it avoids somebody coming in, and I'm saying children, but what if it's her parents or next of kin, and they come in and say, no, I got she said, yes, she has 2 children under 18.
I didn't realize you could see the questions.
Okay. So that's exactly what I'm talking about. So in her situation, she definitely needs to at least go and get a codicil to that will to say that I got divorced, but it was my intention that this will remain in place.
Right. I think that is really good information. That was a great question. Thank you for that question. Please, if anyone has any questions, all of them are good questions. You don't know, you're not a licensed attorney. You need to know this information. And we have an expert in this area who is very informed, and this is what her practice focuses on. So please ask questions. You are very welcome for that, and please ask other questions if you have any. But this is why Jamie has joined us today. We want to answer questions, and we want to get the information out there. Jamie, are there any other considerations that someone should make in estate planning?
Well, I'll just go through briefly a couple of little hacks that they can do to avoid probate. So one of the things that I touched on already was the payable on death. So you can check with your bank and find out, some banks call it other things, but what a POD is basically is saying that in the event something happens to you, who you want that money to go through without having to go through probate. So it doesn't pass, it's not part of your estate, it just on death. It's on death.
Thank you.
And it's POD.
Thank you, Jamie.
Yeah, so it just says who you want that money to go to. And it's not a joint account holder. They're not a signatory on your account, so you don't have to worry about them accessing that money during your lifetime. It's just in the event something happens to you, then the money would go to them, which is a good situation. Another thing to note with that also is if you have a joint account holder, then the money automatically goes to that joint account holder. It's not part of your estate.
Right.
And I think a lot of people don't understand that. But if you have with a bank account, if you have a joint account holder, it's not part of the estate. It goes to the joint account holder. But if you don't, you can do a POD, payable in death, and that will help the money avoid probate. Another thing that you can do for a probate hack is if you are married or if you own property with someone jointly, you can change the deed to make it with joint right of survivorship. And so what that does, that also takes that property out of probate because it passes automatically to the other person, whoever the joint right of survivorship is with on, or the joint holder is on there. Most of our deeds are just tenants in common, but if you change it to joint right of survivorship, then it automatically passes to that person by operation of law without it having to go through the probate process. Also, anything where you have a named beneficiary, like a life insurance policy, an IRA, most pensions, then those things also fall outside of probate. They just automatically pass to whomever you named as the beneficiary.
So a few questions, follow-up questions. Can you change or can you add a minor to your deed?
I don't think so, but I honestly.
No one's asking.
No, I don't want to say yes. I want to say no because we're on camera and it's forever out there that I gave the wrong advice. So I have not added a minor. I think that you cannot, and I probably should know the answer to that, but I don't.
Well, I think I would love for us to follow up with that. I would, because would that be if you wanted to add a minor to a deed and they were say 17 turning 18,
Yeah.
would it maybe not, I mean, just talking through this, people, again, this is something that we need to probably follow up with, but
I would not advise adding a minor to the deed. I wouldn't advise adding a child to your deed, an adult child. I don't advise that.
Okay.
I advise against that. Let me tell you why I advise against that. I advise against that because if that child gets in a credit situation, they can put a lien on your property. Now, if you already, like with the spouse or with somebody, when I was talking, I said this is someone you already have, you own the property with jointly already. So you change the deed to joint right of survivorship. I didn't suggest, and I do not suggest, adding a child who was not already on the deed, unless y'all already, you already have some situation where y'all are already on there together. No, to avoid probate, I do not recommend adding a child to a deed. I don't recommend adding anybody to a deed to avoid probate.
Well, that was going to be another question I had. I had someone send in a question about they got married, they owned their house for 10 years and then got married and wanted to know if they should add the spouse to their deed.
Well, that's a divorce person question.
Well, my response is no.
My background is family law. That is not a estate planning question. That's a divorce question.
Right. And so, but we came, we had the same response. My first response, there's so many ways that you can determine how property will pass, right? Mm-hmm. No, in terms of any family law questions and adding someone to your deed after you get married and you've owned it for a while, because that opens up, that gives that person the right to your property, right?
Absolutely. That's what I said, that's more of that's not an estate planning question. That's a strategical question.
It is a very, yes. So in terms of other considerations, you talked about other probate. I get you're calling them probate, and I love the way you titled that, probate hacks. Mm-hmm. So you talked about. Are there any other suggestions that you have in terms of probate hacks?
Well, of course, there's the trust. A trust is a way to avoid probate. It's a lot more expensive, so sometimes people do not wish to do it, but a trust will definitely help you avoid probate. And even though we still do a will, we usually do what's called a pour-over will, to say that whatever that you forgot to put in the trust, and you want it to be administered according to the terms of the trust. But a trust is one way to completely avoid probate, or minimize what you have to do in probate. Now, you're talking to an attorney who's probably in the minority, because I don't think the probate process in Georgia is very difficult, especially if you retain an attorney and the family is getting along. I don't think it's necessarily a difficult process, and it doesn't have to be super costly, but we never know if they're going to get along. So a trust provides you that protection, and make sure that the things go like you want to, and it might avoid a lot of litigation in the long run.
Are there any other recommendations or considerations people should, are there any other recommendations that you have for people when considering wills and estates?
Well, let me tell you, Melanie, I'll just to be very transparent, I have really been quite surprised by the lack of response with COVID-19. My phone is ringing, but it's ringing with other things, like I'm doing a lot of probate work right now. It's not ringing as much as I thought it would during this time. I'm still shocked that people still don't understand the importance of having these documents in place. And we are literally seeing people die within days. Mm-hmm. And then we've seen all these celebrities and what happens with that. And even with the Kobe Bryant situation, where there was he had the child who wasn't included. And that wasn't even any improper planning on his part. Mm-hmm. He done everything that he needed to do, but this child came along, and before he had the opportunity to update his trust, she wasn't included in it. And then with the Nipsey situation, and what's her name? What's his girlfriend's name?
Lauren.
Yes, with her.
I forget her name, but Lauren.
The Franklin situation, just time again, we keep seeing these situations, but people still don't see the value in this. Even with COVID-19, have a will, have a financial power, have a healthcare power of attorney, have those basic documents in place. And please, I beg you, don't do it yourself, especially with the will. Now, it's okay for me because in the end, I still get paid. I get paid now, or I get paid later. And quite frankly, with probate, I get paid more than I do get paid with wills. But you'll have this will that's probably not going to, one, be executed correctly. It won't have the correct language in it, and it might not even do what you wanted it to do.
Right.
So don't rely on Google or one of these, form documents for something that's important. Spend a little bit of money and go to an attorney.
Right, because viewers, what happens is you end up where you were when you didn't have it, because either the document isn't legally enforceable, or you still leave room for interpretation, which means there's a dispute, and so your family members are still left arguing about what should happen, or how things should pass, or whether it's valid, or it leaves too much room for interpretation when you don't have an attorney, someone who their main focus area is in the drafting of a will or wills and estates. Jamie, anything else? Any other considerations for our viewers?
No, but I thank you for having me on your show. It has been a great opportunity. I hope that we provided some valuable information for people, and that they'll use this time not just to clean up and to do this distance learning, which is, but also to do some important planning for their future.
Right, that's really important. And Jamie, I'm just going to put your phone number up there again. If you need to contact Jamie Terr about any questions for wills and estates, or you need to go ahead and draft a will or estate plan, let's do that now. Don't wait, clean it up. The earth is cleaning up. Let's clean up our homes. You can reach Jamie Terr at 678-253-8133, and you can reach her by email at jterr@terrlaw.com. She's located in Gwinnett County. However, we're virtual these days, so she can Anywhere in Georgia, she can get to you. She can have you sign documents. So, Jamie, thank you so much for joining.
Thank you for having me.
I appreciate you, and hopefully you can come back on soon. Thank you, viewers. Go ahead and email questions at waitonelegalminute@gmail.com or comment or send an inbox message. Thank you so much. Have a good one.
You too.